Time now for Night Court with Beyond Meat and the parent company of Dunkin' Donuts facing a lawsuit tonight over their plant-based breakfast sandwich slogan, Great Taste, Plant-Based. The problem is a Philadelphia-based company says it got a federal trademark for its corporate slogan, where great taste is plant-based, back in 2015. Now, Vegadelphia Foods is suing, alleging the newer phrase, as well as other campaign similarities, interferes with their trademark. So let's bring in tonight's legal eagles, class action attorney Kelly Hyman and attorney Rich Roth. Great to have you both with us.
Great to see you, Shannon.
Okay, so let's put up Exhibit A. This shows the two slogans and the wording side by side. Vegadelphia people say you got this sort of starburst rays coming from behind on both of these products. The Great Taste plant-based versus where Great Taste is plant-based. Rich, they say this is stealing their business, and Dunkin' Donuts needs to knock it off.
Yeah, here's the problem. Where great taste is plant-based is a generic term. Terms like cereal, email, modem are not trademarkable. They just aren't. I've had many litigations where you just have a term of the word destiny. It's not trademarkable. So the fact that they say great taste is plant-based really doesn't get them where they need to be. It's just not trademarkable. Now, what the other part of the argument is that they are making the logo look similar with the font and the colors. Maybe they're getting closer, but it is a generic term. Plant-based, great taste, I just don't see it.
Okay, so let's get to Exhibit B, because Dunkin' has not commented anywhere that we could find. We have no comment from them. Reuters reporting on this says Vegadelphia said in a statement Friday that Dunkin' and Beyond's blatant use of our slogan and lack of response gave us the impression that they felt they are above the law. But Kelly, you know this has to wind its way through the courts. Just because Dunkin's not out there dropping press statements does not mean they think they're above the law, does it?
Well, plaintiffs are making that argument. Plaintiffs are basically contending in their lawsuit that, in fact, Dunkin' Donuts infringed on their copyright and that they filed a copyright. We have to remember the plaintiffs have the burden of proof. And so they have to prove, first off, that there was a copyright. And plaintiffs claim that their slogan, trademark, is copyrighted. And then it's confusing to great taste, plant-based is confusing to the where is great taste is plant-based. And so based on that, the consumers will be confused on the fact of their trademark and their harm financially. Ultimately, Shannon, as you said, it'll be up to the court to make a determination on the facts and evidence, and no one should be above the law.
No, they shouldn't. And I got to admit, I did not know that there were plant-based sandwich offerings or breakfast offerings at Dunkin'. I have a brother-in-law who's a big Dunkin' fan, if you're watching, hello, and he would know all these things, so I should check with him. Let's go to Exhibit C now. Food and Wine is talking about this. They say Vegadelphia argues that not only is the slogan an imitation of Vegadelphia's trademark, but that Dunkin' and Beyond Meat also used placement and imagery in their branding that's nearly identical to Vegadelphia's own branding, including an overlap in font style, stacked text, and even sunray background imagery in a manner that was beyond coincidence. So, Rich, you said you don't think they're quite there. They say this is beyond coincidence, that there's no question about it.
Well, so there's a lot of questions. First of all, we're talking about the Lanham Act, and to my colleague's point, you have to show confusion. And we're talking about a Philadelphia-based company versus a national chain, Dunkin' Donuts. And the question is there confusion? Will someone go to Dunkin' Donuts thinking they're buying this Vegadelphia brand and buy it because they thought it was a different brand? And it's a toughie. It's a toughie. Plant-based, great taste are not terms that are just trademarkable or copyrightable. So yeah, the question is it confusion? Is it confusion if I say the best cereal or plant-based cereal? Or I have generic emails? It's got to be something which has its own meaning, like Xerox or Coca-Cola or Kleenex or Frisbee. So, yeah, it's a tough sell for the plaintiff.
So, Kelly, how would this plaintiff then plan to mount these obstacles and these hurdles that Rich lays out for us?
Well, first, plaintiff contends in the complaint that their food was at fast food restaurants. So there can be confusion. Someone could go to Dunkin' Donuts and think that this plant-based food is in fact their food as well. And so the consumer would go to Dunkin' Donuts assuming that it was the fact and get the product as well. And also the fact that we have to look at the language and the slogan, great taste, plant-based, and they're picking those words from their slogan, and they're going to be harmed. But ultimately the court will make a determination on whether there's enough evidence.
Well, we will track it and let folks know. But thank you for your advocacy tonight, Kelly and Rich. Great to see you both.
You're welcome.
Nice
Your
to see you,
brother-in-law is going
Shannon.
to be the best determining factor.
If he gets on the jury, Duncan's going to win. All right, thanks, guys.